The doctrine of Escheat is a legal principle in land law that governs the reversion of property to the state when an individual dies without valid heirs or a will. This doctrine ensures that property cannot remain ownerless and provides a mechanism for the state to manage such properties. The doctrine of Escheat refers to the process by which ownership of property reverts to the state when the owner dies intestate, without a valid will, and without any legal heirs. Under Escheat, the state assumes control and ownership of the property to manage and utilize it according to public interest and regulatory frameworks. Historical background. 1. Feudal system origin. Feudal England. The doctrine of Escheat dates back to the feudal system in medieval England. Land ownership was tied to fealty and service to the crown. When a tenant died without heirs, the land would revert to the lord or the crown. Lords and Crown. Escheat ensured that land was not left without a responsible owner and remained within the control of the feudal hierarchy. 2. Common law development codification. Over time, the principle of Escheat was codified into common law, providing a systematic approach to dealing with ownerless property. Public domain. The state, often referred to as the sovereign, assumed the role of ensuring public interests by acquiring such properties. Key elements of the doctrine of Escheat. 1. Intestacy definition. Intestacy occurs when an individual dies without a valid will that directs the distribution of their property. Application. In cases of intestacy, the law of intestate succession governs the distribution of the deceased's estate. If there are no eligible heirs under the succession laws, the property is subject to Escheat. 2. Lack of legal heirs. Definition. Legal heirs are individuals recognized by law, such as children, spouses, and close relatives, who are entitled to inherit the deceased's estate. Application. When a person dies intestate and no legal heirs can be identified, the property escheats to the state. 3. Reversion to the state definition. Escheat involves the reversion or transfer of ownership of property to the state. Application. The state takes possession of real property, personal property, or financial assets that have no rightful owners. Modern applications and implications. 1. Real property, land, and buildings. Real property, including land and buildings, escheats to the state when the owner dies intestate and without heirs. Management. The state may sell, lease, or utilize the property according to public policies and regulations. 2. Personal property and financial assets. Financial accounts, bank accounts, investment accounts, and other financial assets without a designated beneficiary may escheat to the state. Unclaimed property. Many states have unclaimed property programs to manage escheated assets and attempt to reunite them with rightful owners or heirs. 3. Unclaimed estates administration. State agencies administer the process of escheat, ensuring proper documentation and legal compliance. Public notice. States may publish notices to locate potential heirs before finalizing escheatment. Legal and policy considerations. 1. Due process legal procedures. States must follow established legal procedures to escheat property, including providing notice and an opportunity for potential heirs to claim the property. Judicial review. Some escheat proceedings may involve judicial review to ensure fairness and compliance with legal standards. 2. Public interest utilization of property. Escheated properties may be utilized for public purposes such as affordable housing, parks, or community development. Revenue generation. The sale or lease of escheated properties can generate revenue for state programs and public services. 3. Challenges and contestations. Heirship claims. Potential heirs may come forward after property has escheated, leading to legal challenges and reconsideration of ownership. Disputes and litigation. Disputes over intestacy, heirship, or the rightful ownership of escheated property can result in litigation. Differences across jurisdictions. 1. State variations in the U.S. state laws. Each state in the United States has its own laws and procedures governing escheat. These laws outline specific criteria, processes, and timelines for escheatment. Unclaimed property programs. Most states have unclaimed property offices or departments dedicated to managing escheat processes and reuniting property with rightful owners.